the accused? Okay. Thank you. Yes, I'm certain Judge Usiko's assistant informed you. Judge Usiko is not available today. She will be here tomorrow. The case then remanded, will it be for 10 o'clock?
Yes, my lady.
So your case is remanded until tomorrow, 10 o'clock. The status of the accused?
Yes.
Tomorrow. That will be the 20th of January, you understand?
The court pleases.
Mm-hmm.
Case number CC6 of 2021, the state is Ricardo Gustavo and Nigel van Wyk.
Mr. Marandetse, morning.
Please, my lady, here appear on behalf of the state in this matter. And if the court allows me, I think I'll just extend my compliments for the new season.
Thank you. I will also make use of the opportunity to do the same to all the colleagues and all present in court.
Number one, Mr. Ricardo So, in respect of accused person number 1, my client wants to start this trial as soon as possible. He has been in custody for so long.
Will you be ready?
Yes, I'm ready, my lady.
Thank you very much. Mr. Nimwata?
As it may please the court, my lady. My lady, we received instruction for accused number 8. That was on the 7th of January 2026. At that time, and also when I was instructed, I was under the impression that it was only one person. I then went to inquire. The following week I was informed that I will also stand in for the entities that he represents. Before that, in there between, I was informed about the tariffs that applies. I then went back to legal aid and they told me, the instruction is for all of them based on the tariffs. I then made the arrangement for disclosure. I wrote to the state, and I was then called by Mr. Advocate Maron Deze the following day to come and collect the disclosure here at court. I came here and I was shown the disclosure. But before that, before I collected it, I went to consult the client in there between. He then instructed me or informed me that he is only appearing on the fiscal matter, but not also on the Nangoma matter. When I came for the disclosure, there were 2 sets of files in 2 groups. Each group consisting of 64 files or volumes. Beg your pardon. I was then informed by Advocate Lutimbezi that I will have to collect all files for both Nangoma and Fiscal. That then also had an implication on as to when I would be ready to proceed with the trial and also consult with the client. But on top of that, I was also not finished with the records of the proceedings, especially the bail hearing proceedings, which I think, unless I'm mistaken, they should also have been disclosed to me. The bail proceeding that took place in which my client participated. That one has not been also availed to me. On that particular day, I then collected only the 64 volumes of Nangoma. They are at my office. The other 64 volumes are still here at court. The reason for having collected only that part, I was of the understanding that maybe the state would then say, we would first start with the Nangoma matter, since the state said, collect all of them, because you need to read all of them. Or if they would start with the fiscal matter, then I must collect the fiscal one. We proceed with the fiscal matter, because even on the list of witnesses, those witnesses are distinct, separated. On the fiscal matter, there are 165. Then on the Nangoma matter, there is another number. To go to your question, my lady, if I'm to give an estimation as to when I'll be ready to start the trial, taking into account that the information I mentioned that I thought should be disclosed to me was not disclosed. That should take me approximately 5 to 6 months for me to be in a better position to effectively defend the accused person. And that, my lady, is also aggravated by the fact that in terms of the legal aid regulations that prescribes tariffs.
You said 6 to 7 months.
Yes.
Yes, I have nothing to do with.
I just wanted to give a reason
With
as
the
to
legal
why
aid status.
that is a contribution, my lady, if I may. That regulation does not make provision for compensation for perusal of the docket in criminal matters. That means it is going to have an impact either on my part or on the part of any other lawyer that is instructed by legal aid by default. As it may please the court, my lady.
But you did accept the instruction.
Yes, I did accept, my lady, and I spoke to the executive director also. After I spoke to the director of legal aid, I then went to speak to the executive director to tell him, look, I would accept the instruction, but you must understand that you are effectively saying I must prepare at the pace which is suitable, financially and in all ways. And they said they've got no problem. As it may please the court, my lady.
Accused number 8. So this 6 to 7 months that your lawyer is now asking for, is that in accordance with your instructions?
Yes, I know. I know.
It is. Mr. Marandetse, anything to add?
My lady, I've had submissions by my learned friends, and I'm tempted to clap hands for counsel for accused number 1. I'm really impressed that she really came on board ready, knowing what is there. My lady, this matter is a matter which everyone knows, counsel knows that it's a matter which is set down for trial. And when counsel is coming into this matter, should be prepared to continue the trial. Because this matter is already set down for trial, there are trial dates. So when you are accepting a brief, you should know what you are going into. If you are not able to adjust to the timetable which has been set by the court and agreed by the other parties, it's better not to accept that brief. My lady, I've heard submissions by Ms. Nemacha, but I can only give a comparison with counsel for accused number 1. They got instructions at about the same time and disclosure at about the same time. But she knows that this matter is for trial. She took time to prepare for the trial, and she's ready to proceed for trial. I expect the same to have happened to counsel for accused number 8. My lady, he came to our office to collect the disclosure. He chose to take part of the disclosure. He chose to leave part of the disclosure, which is still available waiting for him. So that cannot be a reason to say that for his not being prepared to go. He made a choice, a conscious decision. About the Bay records, my lady, the Bay records are court records. The state was part of the records. The accused person was part of the records. They are available for the accused person. They expect to have his own copy. As the court said also it is copy. You can't expect disclosure for the Bay records from the state. So, counsel for accused number 8 should tell the court whether he is with us or is not with us, because we need to proceed with the trial. Yes, the court pleases, my lady.
Thank you. Anything to add?
As it may please the court, my lady, maybe just minor response, Your Worship. I do understand that there may be that expectation that the council should be ready to proceed. But I believe that if we are to apply fairness and look at how long it took the state to be ready for trial after the investigation was completed.
How long would that be?
It took the state more than 6 months. It was longer than that.
6 months.
Even more than that, my lady. From the time the investigation was completed for the state to be ready for trial, it took longer than that. I just came on board. I was appointed on the 7th of January, and somehow the state wants me to do miracles. It's not fair. These are serious charges, my lady.
Thank you. Yes, due to the changing circumstances that came up between the time when I finished writing this ruling about the end of December and now, it will necessitate some changes to the said ruling. I am going then to remand the case until the 21st. That will be Wednesday at 10 o'clock for my ruling as to the application for postponement. I will not require all the lawyers to be present again. Take note then of the court order that will be provided to your officers, as well as what the ruling will then say. For now, however, the case is remanded until the 21st of January at 10 o'clock. Accused number 4, Mr. Bekes, as you correctly pointed out to the court, is already in custody. His case is then remanded in absentia until the 21st of January. I trust he will be back by then, hopefully.
My lady, I will not be able to confirm now, but I will be able to inform the court on Saturday.
Yes, just keep us up to date. If he's not well by Wednesday.
We'll do so, my lady.
Thank
As it
you.
please the court.
Mr. Shanghala?
My apologies, Judge. I was not going to address you, but just 2 things. One, can we record for posterity that you completed the summary of the pre-trial conferences
Yes.
on the 18th of December 2025?
Yes.
It is important because it has a bearing on the fallacy that has been in this court, and I know that perhaps you could have believed it at some point, that there was a delay being caused. There was no delay. I need to say for posterity that the pre-trial processes were completed when that summary was done on the 18th of December 2025.
Yes.
We now sit with an anomaly where we've pled before the pre-trial processes have occurred, and the issue stands out whether this would have to be recorded as a question of law and what its implications are. That is the one issue.
Just a moment.
On to the second issue. You'll recall, Judge, that in the application we made for an adjournment or postponement of this matter, pendente lite the collateral review that is pending in the High Court and which is being case managed tomorrow by the Deputy Judge President Prinsloo. In that application, accused 6 has also indicated the difficulties he has with obtaining representation because of the legal aid rates. In the meantime, it has transpired that apparently in the media and from documentation that is between the representative accused 8 and the ED of the Ministry of Justice, that a special arrangement has been made by the state for prosecutors Lutubezi and Marondedze. They're now or should be receiving a package of 1.5 million, which is nearly 430,000 above the Secretary to Cabinet. What I'd like to know is, and this needs to be recorded, because apparently complicated case, they are required to prepare and work extensively. The same argument could be used for the judge. Is there also a special arrangement for the judge? Why is it that we've been asking for our legal representation to be paid, particularly myself and accused number 4, by the state? But the state apparently has money to give to the prosecutors, but not to us. The issue, no, well, it's a fair trial issue, Judge. Article 12, parity of arms. And it really applies to the Legal Aid Council as well. Because what it does, it transforms the prosecutor from an officer of the court to an angel of vengeance and KPIs, key performance indicators. Because they're now getting 1.5 million, they have to now just prosecute for the sake of prosecuting. And how does that impact justice before you? Because as you know, it is in your hands.
I am not aware of any of this.
I'm prepared to hand up to you some correspondences which have come into my possession. Court orderly, police.
But if a document is being handed up that relates to the other Legal Aid Council, those documents haven't been shared with us.
Well, they can be photocopied.
Sir, I wasn't directing the question to you. My lady, if a document is being brought to the court's attention, otherwise we'll be here giving all kinds of documents in this matter. It hasn't been shared with any of us for us to first indicate whether we object to it being brought to the court's attention or not. And that would mean we have to look at it and see if it's relevant or not to the issues of today's proceedings. Even if those issues are correct or accurate or inaccurate factually, there is nothing that this court can do about that unless an application is brought to this court and a specific order that this court is competent to make is brought. So those are my 2 points. That document cannot be given to the court if it's not shared with us for us to say, especially us that are being referred to as the Legal Aid Council, whether we object to it. And secondly, even if it is handed to the court, what order is the court expected to make in respect of that matter?
Thank you, Ms. Gebhardt. Mr. Shanghala, maybe you can address the last point of Ms. Gebhardt first.
What order should the court make?
Yes.
You see, Judge, judicial notice of issues that affect fair trial is not notice for the sake of notice. It's for the sake of the court administering justice. And where do you administer justice is where there's a fair trial. Where
I cannot take judicial notice of a document that is handed up to me. That is not the meaning of judicial notice.
Well, the court coming to its awareness of the fact that there is a person before the court who is unrepresented as a result of the issue of the scales or the remuneration of legal aid counsel
Yes,
is an
sir.
issue surely the court wants to take up.
So
Because,
you are concerned about the fairness.
yes,
Yes, I understand what you are saying. What I would suggest, but still, what would you like this court
yes, because
to do?
you see, what I'm saying is there are issues of legal representation that affect all of us. I'm talking about those that applied before you for the adjournment of this matter, pendentally to the other matter. Now, if, as we've indicated in that application, if we are unsuccessful in the Supreme Court to get our estate released from the POCA order, we will have to get legal aid representation. And we have said time and again in this court, before your late brother Shinango, that representation is not just representation for the sake of representation. It's competent representation. Competent representation means a person who is remunerated at a level that will allow that person to leave other cases and concentrate on this case, which has been apparently characterized by the Prosecutor General as a very complex matter with 340 witnesses, with over 165,000 folios. And to prove it, the state itself has gone to ensure that its representatives are apparently adequately remunerated. Why would it then not be an issue of relevance before this court? So that addresses the second issue of Madam Gebhardt. The first issue of it hasn't been given to them, that's fine. Let the copies be made. Let them read it. It would ultimately result in, if the court wants to do justice and fairness, in inquiring into if it is possible, as Justice Shinengo once said here, if PG, you went to see these people about legal representation and you discussed about the rates being adjusted for their legal representation, why would you then oppose, for instance, when they apply for their estate to be released, and et cetera, et cetera? So this is very germane to legal representation and fairness. It would behove the court to then exercise its vast powers. You have a vast reservoir of powers, particularly under Article 25. When somebody raises that their rights are being infringed, and they're being infringed by a trial being proceeded in the haphazard manner that it is, without the ability to be legally represented and properly advised. So that is the relevance. Surely, the question then behoves me, because I want a fair trial. Are these arrangements being made also for the judge? Is it just these two prosecutors? Why am I not legally represented as a former Minister of State? I've asked that. But the same state, the same ED is prepared to give them one. They say it's an issue. Really, we cannot say it's not germane. And the court has a vast reservoir of powers to see what it can do to ensure justice. The suggestion being made in one of those letters is that maybe the court should subpoena the ED and come and inquire why those rates are being paid to the prosecutors and not to the other legal aid counsel, for instance. So it is germane. I think I've made the point.
Thank you.
Apologies, my lady. If I may also just comment on Mr. Shanghala's submission, because I see the letter. One is my letter to the ED, and one is the response that the ED wrote to me through the Director of Legal Aid. I think it's very important that I also get the opportunity to say something. May I proceed, my lady?
Just a moment.
Yes, like I have indicated, my lady, there are two letters One is the letter that I wrote to the ED about the tariffs, when the Director of Legal Aid indicated that if I want to take it up further, I can take it up with the ED. I wrote to the ED, sent to the ED directly through the PA email address. The ED wrote back to me, but he sent the letter to the Director of Legal Aid. All of the things that were mentioned by Mr. Shanghala are in my letter and also in the letter of the ED. In fact, in the letter of the ED, he appears to acknowledge and he says that the instruction of those councils are different. On that score, my lady, I have no objection for these letters to be received. I'm the one who authored one that was responded by the ED. The same person who is alleged to have approved remuneration for the State Council and for the other lawyer that is appearing in another case, that is the Caprivi Treason Trial Appeals, for people that are already convicted.
So there's nothing in those two letters pertaining to the alleged extra remuneration of the state?
There is. I mentioned it in the letters.
In your letter?
In my letter.
Yes.
And I challenged him, and I said, if it's true, I spoke to him in the letter, say, if it's true, and it's given based on the Fishrot case, the so-called Fishrot case, then that is an acknowledgement that the case is such serious that...
Yes, I prefer we use State versus Gustavo.
Yes, it may please the court, Your Worship. Thank you. Maybe copies can just be made for the benefit of all the councils that are before court. One more point. In fact, the ED seems to indirectly threaten.
Yes, maybe we can park it there.
My lady, there's just one last thing. It relates to the disclosure that Mr. Marondeze graciously and Mr. Lutubezi had organized for us, which is apparently somewhere here at these offices. If we can be given an opportunity to see that disclosure and be able to access the office that we have now been given as we related to you last time. It still hasn't happened. And I hope that's not the disclosure that was given away. I hope not.
I don't think so. Mr. Marondeze, the disclosure is in the office that was provided to the unrepresented accused?
My lady, we gave
the key of the office. Where's the key?
It should be with the registrar, my lady.
Okay. Yes, I think we can just, when we adjourn, just sort it out amongst all the parties, please. Who is in charge today of transporting the accused persons? Nobody. Yes, officer, the accused are asking for an opportunity to look at the disclosure that is in an office here. So please do not remove them immediately after we adjourn. They can be given an opportunity to look at it. Do you understand? Thank you. Yes, I do not want to descend into the waters of the financial arrangements between the parties. I do understand that it might become an issue of fairness whether, yes, I will need time to think about this matter, whether I will take it on and resolve it, so to speak. This can then also be dealt with further on Wednesday, the 21st of January. Then case and remanded until that date. Accused 1 through to 9 in custody at the Correctional Services, Windhoek. Accused 4 in absentia. Accused number 10 bail extended until 21 January.
That's the court, please.
Thank you. Ms. Brendel?
I just have a concern that was brought to my attention by accused 7. I understand that there was at some point an order or directive to the media or to persons here that they should not take pictures or videos of the accused persons.
Yes.
Yes. So, however, even myself, I have observed that they are taking videos or either pictures. So perhaps that order should just be reinforced.
Yes, the permission to record is granted by the Judge President. I'm sure the members of the media are all aware of this. It's a procedure that you follow, as I understand it, for each and every case that you wish to record. And it is clear in the wording of that document that the only people that can be photographed is the judge and the person addressing the court. So
it should actually be made clear to the members of the media.
Before you came on board, Mr. Alexander, this was already very clearly stated. I think on the first of the second day I took charge of this case. It was brought under their attention.
That's a good.
But please, members of the media, just again read the document that grants you the privilege, it's not a right, the privilege to be present in court and to record these proceedings. Thank you. Ms. Brendel? Is our other accused here? Then we can proceed.
In case number CC8 of 2025, the State Legislature
Before, can we be excused?
May be excused.
If court pleases.